Hi, my name is Natalia Willett and I'm a real estate attorney here in the state of Florida. And today I want to talk to you about tax deeds. But what am I going to talk about today regarding tax deeds? I want to talk to you about what happens in the quiet title process when there is a prior owner who is deceased. How does that affect the whole quiet title procedure? All right, so I'll start again with what is a quiet title. An action to quiet title is what the vast majority of title insurance underwriters are going to require in order to ensure a sale where you, as the owner of the property, have the property via a tax deed. So in that case, the action to quiet title will be done through a law firm. It is litigation to clear up title. And if the prior owner, meaning the owner prior to you, died, there are certain steps that are taken which prolong the process, but they are required in order to have an effective and correctly done action to quiet title. So here are some of the things that will happen. If let's say my firm is lucky enough to find an obituary that identifies heirs, then we will go based on that as far as naming the estate, naming the heirs, and then they have to get served as well, each of them individually, wherever they are in the country or in the world, as part of the litigation. If, however, it is like the majority of proceedings, people pass away, nobody puts in an obituary, or if there is an obituary, it's very minimal. It doesn't say anything about family members, etc. Then what we do is we petition the court to have an ad litem appointed. So an ad litem is another attorney or a party who is going to act at the behest or serving the interests of that estate. And their job is to do a thorough search where they look for this person who passed away. They are going to request death certificates. They're going to inquire as to potential family members based on what they find on that death certificate. They're going to do a thorough report. This report usually takes a couple of months to do because, again, we are expecting them to take their time and research appropriately so that we know who the people are to properly serve. When we get that report back, that report will let us know who the heirs are and the last known addresses for these heirs. And so we have to get summonses issued for each of these heirs so that they can get properly served and notified in these proceedings. Sometimes those heirs are at the last known address, sometimes they are not. And ultimately, we may have to do a published notice of action of the proceedings for those heirs that we could not locate and we just couldn't find the latest addresses on. After all that is said and done with the report of the ad litem, the service of process of those peoples, that could add generally 3 to 4 months to the standard quiet title action. And so it's something for you to keep in mind when you bid at auctions where the prior owner is deceased, or it says estate of, or they're of a later age. If you've looked up at all to see like how old the prior owner was, be aware that this can prolong your proceedings. So instead of it being the average 6 months or so to do a quiet title suit, it might be closer to 9 months to a year to finalize that action to quiet title. All right, I hope this was useful for you all, and good luck out there, investors.